basis of the motion. Your Honor, before going to the requirements of Section 33 of the Prevention of Terrorism Act, I wish to give a brief background to this particular matter. Your Honor, the DPP lodged an appeal at the Supreme Court. That is petition number 39 of 2018, in relation to two Iranian nationals. Petition number 39 of 2018 in relation to two Iranian nationals. And the said petition was heard before the Supreme Court on 11 December 2018, and is pending judgment. The investigations, the current investigations, surround the circumstances under which the three respondents, and a senior Iranian diplomat, who we've not named in the application for obvious reasons, pending the advice from the Minister of Foreign Affairs, senior Iranian diplomat, who we've not named in the application, pending advice and direction from the Minister of Foreign Affairs. Were involved or have been involved in trying to illegally secure the release of the two Iranian nationals whose judgment is pending at the Supreme Court. Your Honor, an application under the provision of Section 33 of the Prevention of Terrorism Act requires the prosecution to prove four particular grounds The first ground being the nature of the offense for which the suspect has been arrested. Secondly, the general nature of the evidence for which the suspect has been arrested. Thirdly, the inquiries which have so far been made by the police in relation to the offense and the further inquiries which are to be made. The inquiries which have been made by the police in relation to the offense and any further inquiries proposed to be made by the police. Further inquiry proposed to be made by the police. And the last ground, the reason or the necessity for continued detention of the suspects produced before court. Your Honor, these four grounds must be proved on the balance of probability as stated in the bail bond policy guidelines. Bail bond policy guidelines. Your Honor, looking at the first ground, on the general nature of the evidence, of the general nature of the offense, Your Honor, the first respondent was arrested on the 22nd. The first and second respondent were arrested on the 22nd February, while the third respondent was arrested yesterday, and the time of arrest of all the three respondents, they were informed of the reasons for the arrest. In reference, we make reference to paragraph 7 and 8 of the affidavit in support of the application. Your Honor, the investigations relates to offenses listed in paragraph 16 of the affidavit in support, among others. And the offenses listed in paragraph 16 that arise from the Prevention of Terrorism Act arise from the planned escape of the two Iranian nationals. Your Honor, we have therefore satisfied the first ground on the general nature of the offenses. Going to the second ground, in terms of what so far has been picked up by the applicant from the time the respondents were arrested. Your Honor, I refer to paragraph 10. Paragraph 10, which lists what each and every of the respondent has done so far in relation to the planned escape of the two Iranian nationals, including the involvement of the senior Iranian diplomat, go briefly to those particular parts that they've so far, what has so far been gathered. Is that the first respondent was introduced to the said Iranian diplomat, the senior diplomat, during the month of May-June in 2018, by a person who so far we'll only refer to as A. Okello. Details in respect to this individual are so far scanty, and efforts are being made to get his full identity to ensure that he is apprehended. Your Honor, first respondent later met the said senior Italian diplomat, senior Iranian diplomat, at a local hotel This hotel has been identified, and the investigators are currently in the process of trying to obtain the CCTV footage. Of this particular meeting that was held with the Iranian diplomat, senior diplomat. It's at this meeting that they also met another individual who we'll only refer to as H. Noor. At the same hotel. And later on, the first respondent is said to have met the said Noor on a proposal which is said to have been given by the senior Iranian diplomat and they did meet at a hotel within the CBD area. And that particular hotel, Your Honor, is not named for purposes not to jeopardize ongoing investigation. It is at this meeting that Noor informed the first respondent that they wanted someone to help them with the removal of the two Iranian nationals who are in custody, and to ensure that they are repatriated, they are taken back to their home country as quickly as possible. Later, did meet the senior Iranian diplomat at his residence, where the said Noor was also present. the discussion of the removal of the 2 Iranian nationals was also discussed. And the instructions given to the first respondent were that the Iranian embassy or government should not be seen in their particular plans. It's at this meeting at the senior diplomat resident that the first respondent is said to have been informed of the fact that the diplomat, the Iranian embassy, was willing to spend up to US dollars 150,000 Your Honor, it is later the first respondent sought the assistance of the third respondent and an unknown date in January this year, the third respondent. Third respondent, who later during the month of January this year informed him that he had somebody who is well connected and was willing to help them carry out the assignment given to them by the senior Iranian diplomat. Your Honor, later the 3 respondents, during the first week of February this year, met at a hotel in Hurlingham, and this particular meeting included the second respondent, who stated in the said meeting that they should ensure that they have 2 air tickets and their passports. The passports in relation to the 2 Iranian nationals in custody are ready. The 2, not 2 Iranian, they are 2. It is during this meeting called the said senior Iranian diplomat, who it is said informed him that the two individuals, the two Iranian nationals, their passports had expired. But the diplomat, the senior diplomat, was going to facilitate them with a temporary travel document. For purposes of facilitating their travel. Your Honor, the respondents, the three respondents, and the senior Iranian diplomat met at a hotel at a parking bay at one of the shopping malls within Westlands area. Where the said diplomat is said to have showed the temporary travel documents to the respondent, and is said to have told the second respondent that he received his payment after the two Iranian nationals were out of the country. Your Honor, diplomat booked a flight for the two Iranian nationals in custody and a third ticket for himself, and the three were to depart the country on 11 February 2019. On 11 February 2019. Your Honor, this is despite the fact that the two Iranian nationals are in lawful custody pursuant to the orders issued by the Supreme Court. Your Honor, a day before the scheduled travel, that was on 10th February this year, the three respondents and the senior diplomat and another individual who is yet to be arrested met at a parking bay of a popular shopping center within Nairobi, Westlands area, in furtherance of the plan. Your Honor, so far, in terms of the information received by the applicant, so far, the few areas that are pointed out is what the applicant has so far received. And there are inquiries which the applicant requires to make is to obtain CCTV footages of the various hotels and shopping centers, these are arcades, where the three respondents and the senior Iranian diplomat met. Hotels and shopping centers, shopping arcades, malls. And there is also need to obtain CCTV footage from the office of Qatar Airways, for purposes of analysis. And also to obtain the call data records for purposes of analysis for the three individuals, three respondents and their associates. Purposes of analysis. As stated in the earlier paragraphs, there are mobile phones to be examined. And this will take time due to the fact at the moment, as this court may be aware in the applications that are pending, is that there is huge backlog at both forensic laboratories, at CID headquarters and at ATP headquarters. This is also in the early application we had really referred to. Your Honor, These are some of the inquiries that are required to be made. Your Honor, going to the last condition, the necessity for their continued detention. Your Honor, I wish to point out, one, the seriousness of the offense being investigated, the offenses being investigated. They arise from the Prevention of Terrorism Act. They attract a stiff penalty, and hence this court, pray that this court looks at the seriousness of the offense in view of increasing the temptation of the respondent who abscond. Your Honor, secondly, this court has stated in paragraph 15 the issue of associates who have not been apprehended. And the release of the respondents will interfere with their arrest. And there is also a need to carry out detailed interviews with the respondents. Emphasis interviews with the respondents before any decision is made by the DPP. Your Honor, from the brief that we've given, that is in the affidavit's own in support of the application, it recognizes the fact that the involvement of the respondents in planning and executing the planned escape of the two Iranian nationals in lawful custody shows that they do possess the capacity and financial muscle to interfere with the investigations, interference with witnesses, possible witnesses, and also based on the fact that one of the charges being investigated is obstruction or hindering the course of justice. This makes the situation that the respondents are in a more serious situation because it involves the administration of justice. Your Honor, the cumulative effect of some of these areas that we pointed out is that it shows that the respondents are flight risk, more so especially the second respondent, who is a Ghanaian national. This increases the risk of them absconding during the course of investigations. we pray that this court take judicial notice of the terrorist act that have been committed in the country and the need to prevent the same. We also pray that court
They also tell you that they would want time with them, and that's still the number of 30 days they're talking about, to get their telephone details. They want to get the data, call data, and information of who they have been communicating with. It has not been shown to you, Your Honor, who among the suspects or the respondents works with any service provider like Safaricom, Airtel, so that they can be able to be present to give that kind of information. And yet they are also telling you they'd want to analyze the data that is in the phones and the communication that the suspects have been using. The data is in the phones that they have already collected, in the computers and the laptops they have already collected. Unless they're computer illiterate, then they would not require the suspects to be present there. One of the other things that we've been told is that the police would want to have time with the respondents to conduct what they call a detailed interview with the respondents. Why would this require 30 days when they can do it within the next 1 hour? Yeah, I'll give you an example of the second respondent who has been in Mousavi police station and has been there for 3 nights, including the days, 3 days and 3 nights. And what has been going on there is that he has just been sitting and asking for permission to sit in the sun because he has just been locked there doing nothing. Yet the same officers would want to come to you and ask for 30 more days so that you can still go on and sit in the sun. If they were serious with doing serious interviews, those 3 days were sufficient when he was just sitting there. And even in the process, they give him very bad food. told that these respondents are such bad people that they are going to be investigated for terrorism activities. But when you look at the affidavit that has been brought before you, what are they talking about? They are talking about wanting to aid some prisoners to escape. And therefore, prior to trying to aid is the conspiracy of that offense. So the prosecution, in their very articulate manner, they are very experienced and expert in this. They try to paint a picture of very bad persons in this court. And they're very good at it. And my friend, this Ondimumade, actually performs very well in that matter. So when you look at that affidavit, where does terrorism... Sorry. So then that's why they try and bring out paragraph number 16 in the affidavit, whereby they are trying to tell you that there was an obstruction of hindering the course of justice. The obstruction has not been done, the hindering has not been done. So what are they talking about in that paragraph? If this is not a creation, it is an assumption, and a very bad one as well. And they're being told again they are interfering with the judicial process contrary to Section 150, Section 15 of the Act. They're not being told how that was done, when it was done, where it was done, and exactly by whom of the three respondents. So as I was saying, Your Honor, this is the kind of picture then they paint and they make it look like it is such a serious issue. It is not. And if they were interfering with the judicial process, with which judicial officer? So to color it more, what do? They take a step back and tell you they're also investigating a high-ranking Iranian official. Who they do not name and do not tell you what position he holds in the community. But even that itself is not an act of terrorism. It is not. So, Your Honor, this is where we start asking you then to start protecting us. If you leave us at the mercy of these people once for 30 days, you can imagine then what will happen. If they can paint such a scenario, we are at your mercy, not there. Don't leave us at their mercy. These are not very good people. And they're my friends. Then the investigating officer then comes and tells you the second respondent in this case is a Ghanaian national, which by any imagination is not a bad thing. But then they try to tell you that he's a flight risk. Yet when they called him to go and appear, he told them where he was and they went and picked him. If you wanted to abscond, that was the time when you had your time and opportunity, but he did not. It only shows you one thing. This is a good man. But for them to come to this court and tell you the flight risk, then they must table some material. Forget about probabilities as to say by your friend this campaign. Not probabilities anymore. All the rulings that we have had in the High Court say they must table some material. They must show that. If there's a flight risk, has he planned to travel? Has he bought a ticket? Has he made travel arrangements? That has not been given to you. The only thing they tell you about tickets is that the high-ranking official and some two people, Iranians, were planning to travel. None of them is from Ghana. So for them to say that, where did they imagine this story from? Because it cannot be true. It is imagined. Remember, what you have today before you is just a mere affidavit supporting the notice of motion. It does not have the names of the witnesses, if any, in this case. There is no charge sheet in this case. And therefore the issue of witnesses does not arise because there is no case before court, only in this application. And even that application only mentions one name of a person called A. Okelo. Prosecution has not shown how these respondents have interfered with the witnesses, who we do not know, who you do not know, who are not in this affidavit today. Interference then must be real interference, direct or indirect. If they have not told you what kind of interference, then you are not able to know whether it is direct or indirect. Therefore, you have nothing before you to determine. You have nothing before you to determine. And as I said, Your Honor, they paint such a nice picture. The person who is supposed to be giving out money and is from the embassy, allegedly, for this particular moment, nothing is established. $150,000. But then the prosecution comes and tells you that it is the respondents who have got the financial muscle. For them to tell you that, they need to prove that these people have financial muscle. Where are bank statements? Where are account details? Where is money that they found them with it? So again, they paint this very nice picture that they have a strong case, but it has no proof. And this is not a court that just goes for imagination. This is a court that must follow facts, and that is why we are here. So let them not throw wool over your eyes and tell you probabilities. So if they have not put anything to do with financial muscle, interference, and absconding of flight risk, then what exactly do they have before you today? But whether they come under Section 33 of the Terrorism Act, they forget one thing, that the supreme law today is the Constitution. That is what we need to rely on, and nothing else. Everything else is subservient to the Constitution. But they've also quoted very well Article 49(1) of the Constitution. Yes, they have come to this court and have told us why they are holding the suspects. But then let us come to the part that says they must give compelling reasons, which they have not done. The suspects have come to court, but they are not given compelling reasons. And these fundamental rights do not belong to the state. They cannot pretend to own them so that they can be able to dictate to you who to release and who not to release. And that is why Article 19 is clear that these fundamental rights belong to an individual and not to the state. So perhaps my learned colleague, Mr. Ondimumade, and this is my friend, had he looked at that part, he would have realized that he has no right to even come and tell you anything. And Article 20, then this is where, Your Honor, you are bound, and the prosecution is bound, and all state officers are bound by it, whereby it says that all must be done to try and realize the fundamental rights of an individual. What does that mean? It means by you must want to start by wanting to grant, not to deny. So while we are hoping that you will want by wanting to grant, the prosecution come here and try to tell you you will not grant those. And that is why it is important to then look at Article 22, which is very clear that in case we realize that our fundamental rights are going to be breached, and this is what is happening exactly here today, then what do? We rush to you. And once we rush to you under Article 22, that is when you look at Article 23 and 165 of the Constitution, which says you have a right to then grant this fundamental right to us. They have told you so many things of what the investigations they have done, but have they attached the investigation diary to it? Because that is what can be then the truth. But for me, Your Honor, and our clients, the affidavit they have given you just gives a nice story, a nice reading story. Nothing is the truth in that issue. So they come with an affidavit and tell you this is what the suspects have done when they enumerate them. We do not have an opportunity to deny that because this is not a charge. But my instructions of my client are these stories are not true. So when somebody like the first and second respondent are called on phone and ask where are you, and they say where they are, and then they are picked. These are the kind of people that you can be able to grant bond. Why? Because they have shown, first of all, they are honest and their people can be relied on. And they have shown that they cannot abscond. And they have shown that they have got fixed abode. So grant them bond so that whenever these officers want them, so that we avoid this issue of just going to sit in the cells and eating very bad food, they can be able to call them and tell them, come today, we need to talk to you. When it comes to the foreigner, give conditions, give terms, let him report maybe on a regular basis. And even if you look at this affidavit, you can see that this is a story that seems, according to the affidavit, hatched by the Iranian embassy official who is not here today. So if he's the author of that story, why do we have these people? That is the strength of their case, and you can see how weak it is. I would say this, Your Honor, and without being embarrassed, if you are to give them any time, give them today so that we can come back tomorrow. That deep interviews and interrogations can be over, because that's the only thing that is remaining. Everything else is mechanical, it is technology which the suspects cannot provide. But one that made me feel a little bit aggrieved, Your Honor, is when they tell you that there is a backlog of forensic material at the ATPU and government analyst offices. So if they have that problem there, maybe, I don't know, it's incompetence, or whether lack of facilities, or lack of officials, how can that be the problem of the suspect? How can that be their problem? So you're being told, keep them because we took on a jam mahali, then we can bring them later. So they suffer because these people are not able to do their work. Your Honor, you cannot agree to that today. Because if you do so, you'll have been so unfair to the suspects. Let them do their work. The day they have cleared that backlog, then they can say, now, bring them back here, then we can go and analyze. They are not even giving you a time limit, but they are just telling you 30 days. 1 day is bad enough, Your Honor. 1 day is bad enough. 30 days, you cannot even imagine. That is all I wish.
Your Honor, the third respondent is managing the Nairobi office, which, Your Honor, for avoidance of doubt, it is situated at Post Bank Building, 3rd floor. Post Bank Building, Your Honor, 3rd floor. Your Honor, this is not. Is, Your Honor, at Post Bank Building within the CBD, 3rd floor. Your Honor, this is not news to the applicant, as indeed, in the supporting affidavit to the motion before you, paragraph 9, Your Honor, there is an express admission to the undisputed fact that the third respondent is an advocate of this court. Paragraph 9, Your Honor, of the supporting affidavit to the motion. Your Honor, that was a fundamental material fact that might change the course as you retire in your determining whether or not you shall grant the prayers assault against the terrorists. And more importantly, Your Honor, it's also not disclosed to you that the third respondent was a lawyer for both the first and the second respondent. Yet, Your Honor, he has an advocate-client relationship to both the first and second respondents. That, Your Honor, at all material times relevant to the matter before you, the advocate-client relationship between the third respondent and the first and second respondent was not only active, Your Honor, but still subsisting to date.